My name is Alicia Mundy. We have a story in the Journal today about a case that will be heard before the Supreme Court next Monday, the day before the election. It may be one of the most important cases for the business community and for consumers in the past 50 years. What's up for grabs here is the consumer's right to sue corporations for products that kill them or cause them damages. The facts of the case are pretty horrific and no one disputes them. The case is called Wyeth v. Levine. Wyeth is a giant drug manufacturer. It makes many products. Miss Levine, Diana Levine, is a former musician. She went to a hospital with a migraine and lost her arm. What happened is fairly simple. She went in with a migraine. She was nauseous. They gave her a medicine made by Wyeth to help the nausea. It went into her artery instead of into her vein. The mistake turned to gangrene. She lost her arm within a few days. And she was a guitarist beforehand. She has lost her career from that perspective. The issue in this case, however, is what was on the warning label of the drug given by the hospital. The warning label always said, this drug can cause gangrene if given incorrectly. But it didn't say, and here's some ways not to give the drug. That part is up for grabs, and what it comes down to is whether what the FDA puts on a label is all that you need to know and whether that's enough for the drug company's warning, or whether if a drug company knows there are other problems, the drug company should proactively step forward and say we want to strengthen the label. Before the Supreme Court, the drug company and the U.S. government are arguing that the FDA knows what it's doing, that they are the final arbiters, that they are the pros. On the other side, representing the consumers and Miss Levine, are a host of people who say, hey, if you've been awake for the last 10 years, you've seen major drug disasters in which the FDA messed up, didn't know what it was doing, was misled by companies, or bowed to influence by companies' lobbyists and didn't make labels stronger. The FDA can't be relied on, and in fact, all of the former New England Journal of Medicine editors have signed a brief before the court saying you can't count on the FDA, we've seen too many problems. So this is going to be an interesting case, and as sad as the facts are for Miss Levine, it is not black and white. One of the justices has already shown how he feels about this. Justice Stephen Breyer, in an argument that's similar to this a couple of months ago, basically unloaded on the lawyer representing the consumer that day and said, who do you want making your decisions on what goes on with a drug? The FDA, who are the pros, or a group of 12 people randomly chosen for a jury? And he signaled where he's coming from. This is going to be a very important argument, and tens of billions of dollars are at stake.